witnesses whose statements have been admitted that were originally and initially intended to testify found on behalf of the prosecution. In the course of time, they showed reluctance to testify, and eventually they testified. However, the nature of their testimony was not exactly similar to what was contained in their original statement that they had given to the prosecution. And at the end of their testimony, and in view of the fact that they did not testify, let's say 100% as per their original statements, the prosecution applied that the original statements should also be put in. And after the arguments, the court said, yes, we will accept the original statements to see it together with the testimony that had been adduced during the trial by the witnesses. And so that is the nature of what is at hand.
What does that mean? Does it mean that the statements have become true and what they said is not true?
Okay, let me explain that. Yes, let me explain that, yes. The application by the prosecution is that the statement should get in for their truth, for the contents of those statements to be treated as an accurate statement of fact representing the nature of the prosecution's case. The argument also is that these witnesses would have testified along the lines of their original statements if a certain degree of interference had not been applied. On our part, for the defense, we were arguing that the testimonies of these witnesses should be what they came and said during the course of the trial, what they said under oath, what they said under circumstances when they had been given warning that they must say the truth. And we were saying those conditions did not apply when the statements were being recorded. The court then had to make a decision on two issues. One, whether on the face of it they had the impression that there was any interference, and number two, whether they can allow a statement recorded by the prosecution, which is one of the competing parties in the course of the trial, to go in as a statement of truth as against or as opposed to the testimony that had been adduced during the trial under oath. And I just want to emphasize that the court's decision accepting the statements is to this extent. It is to the extent that the court says that it needs all the material that may be necessary for it to know the truth. Now that, to my understanding, is that it is not necessarily being taken in as the truth. It is not being taken in as the final position of the case. It is being taken in so that at the moment when the court will be deciding the guilt or the innocence, then the court has all the material before it. And the material are in three categories. The first one is the testimony of the witness during the course of his trial. That's one set of testimony. The second set of testimony is what the witness said in their recorded statement when they were being interviewed by the prosecution. And the third set of testimony would be what became of the witness testimony in the course of cross-examination. In other words, what the defense put to the witness and elicited in the course of cross-examination. So those are the three issues that the courts will have to use to determine the guilt or the innocence.
But the defense is appealing against that decision.
Yes,
am I correct?
Yes. We've appealed. I don't know if you want me to say something about the appeal.
I don't know whether to incriminate yourself, whether you put yourself in trouble with the ICC. The decision is yours.
Yeah, okay. We've appealed about 4 issues. The first issue is that in the traditional way we know testimony, testimony entails an element of an oath. It entails an element of an oath with the alternative of affirmation, that a witness appears before a court and makes a solemn commitment that he's saying the truth, and acknowledges that there are consequences if he's not saying the truth. Now, the decision to admit these statements has the effect of saying that what you record in the field between yourself and an investigator is equivalent to testimony. And that is the concern that we have taken to the appeal, saying can a statement, can a material that is taken short of an affirmation or an oath be treated to be testimony? So that's the first issue. The second issue we've taken to the appeal court is the question of retroactivity. The case started, well, the case was confirmed about January 2012. The hearing started around September 2012. Rule 68, under which that application was made, was amended around November 2013, which is slightly over a year after the case had started. And our argument is that a rule that was initiated in the course of the trial should not be used to apply retroactively so as to start governing a trial that is already ongoing. Of course, related to that argument is the issue of whether or not Kenya was intended to be excluded from the provisions of that amendment. And I know Kenya government applied to participate in those proceedings, and its application was rejected. And so that is where we are. The third issue is that the rule requires, or the rule allows, admission of a statement when a witness fails to testify. And our argument is that failure has the meaning that the witness comes to court, walks into court, and decides not to testify, or rather keeps quiet. Now that is different from a situation where a witness comes into court. A question is put to him directly, say, were you at a certain location on a given date? And the witness says, no, I wasn't there. Now, our argument is that that is not failure. He has not failed, he has actually clarified his position. And I think those are the issues probably that, yeah, well, of course there are many, but the others are a bit too technically legal.
Being a lawyer representing the victims, what do you make of this?
Well, I think I would want to start by saying that Rule 68 is problematic because it is a rule that deals with exceptional circumstances, and that is why I think there has been a lot of debate around it. But the fact that it deals with exceptional circumstances does not necessarily mean that there may be no place for it in the scheme of things. What I mean to say
things means this case, the present case.
Not just this case, but in any case that is presented before the International Criminal Court. Now, Rule 68 deals with situations where witnesses have failed to testify or where they have disappeared, and it is designed with the purpose of dealing with situations where, for example, there is witness interference from whatever quarter. And it is important that there are rules designed to ensure that if there is some interference with the due administration of justice, then that is not the end of the matter, that something is done to ensure that the truth is brought before the table. And if you look at the Rome Statute, Article 69, sub-article 3, does provide that the court has the power, has the authority to bring in whatever submissions of evidence that may be available for the purpose of establishing the truth. And I think it is within that context that Rule 68 itself is having life.
What do you say of the fact that the court admitted these witnesses because of what they think was interference? And what do you think of what is happening now in this country after the court has admitted this statement, and what is happening? The reaction of Kenyans, they have gone haywire in terms of politics.
Yes, I think I will want to dwell more on the legal aspects rather than the political aspects. I see the ICC process as a legal rather than political process. But having said that, let me say that the presiding judge himself, in his partly concurring opinion, did recognize a number of things, and one of the things that he recognized is that the trial before him is not a trial regarding what we call Article 70, interference with the course of justice, as it were. And therefore, on that basis, in fact, a lot of material that the prosecution had presented and wanted to be reckoned into evidence was not allowed, and that was not allowed by all the three judges. And I think that that is important. It is important to not to divert from the question of what is before the court, and what is before the court are charges of crimes against humanity against Honorable William Ruto and Joshua Rapsang. So what the court basically was saying is that it does not want to go at this stage into the question of who might be responsible for the witness interference. So it is just a question of, let us have all the evidence on the table, then let us see what weight is going to be attached to evidence that is provided in court through after witnesses have been affirmed or have taken oath, and let us see what weight will be attached to what they may have said before they came to testify. And I think that is important, because the process, the ICC process, is seeking to establish the whole truth regarding what happened in 2007-2008.
So what do you say of your case and the fact that this admission has caused uproar in this country?
I would want to start by saying that I would very much like to take the same position that Mr. Nderitu has taken, being that I look more at it as a legal process than political process. And so I'm hesitant to get involved in the political discussions that surround it. But having said that, there are a number of issues that Mr. Nderitu has raised, which I think I would really want to clarify. The first one is the issue of interference. And the arguments around the question of whether or not the witnesses were interfered with attracted two important and significant issues. The first one is that the decision of the court is that they are not called upon, and they do not intend to decide on whether the accused person specifically were responsible for witness interference. And for them, it was good enough for them if, number one, they set a standard upon which to assess or estimate if there was any interference, and number two, if in effect it had any influence on the witnesses. And the second one is, of course, the issue of the standard. And one of the issues, of course, we've taken on appeal is the standard of proof that the court came up as a test for this issue of interference. The familiar standards of proof that are familiar to us in common law jurisdictions, that are familiar to Kenya, would be a standard of beyond reasonable doubt and a standard of probabilities. But then the trial court in this case introduced a new standard called a standard of sufficient particularity and sufficient particularity and with probative value. And we are saying it is very difficult to place your finger on what that kind of standard is. It is a standard that is foreign. And so this decision has very many issues surrounding it. It is, of course, a new rule. It has challenged legal process in every way. It has challenged the legal process in the sense of what we know in terms of testimony, in terms of the obligation of a witness in court, in terms of standard of proof, in terms of all these issues. And Mr. Ndedidu has said that there does exist Rule 69 under which the court can accept material to go on record for purposes of it comprehending the background. And may I say that Rule 68 under which these documents were admitted is different in scope and extent from the Rule 69. And in a certain way I can say positively for the defense that if these statements had been accepted under Rule 69, it's more probable than not that we would have no problem with that admission, because it will be for purposes of appreciating the context, the circumstances that relate to the situation in Kenya in the period 2007-2008. However, when it is admitted under Rule 68, it has the added element that it is being admitted for its truth, and that's where we are aggrieved at. That is where we are very concerned about. Yeah, that's what I wanted to say.
Are these statements by public knowledge?
Yes.
Do we know what the content is of this statement?
Yes, what I'm telling you are contents that are in public
whatever
ruling.
those people said is don't know what they said.
Oh, no, that's
I'm asking this because a politician who is a lawyer,
yes,
did claim in that public meeting in Kuresoi the other day that the statements are incriminating not only to the accused but also the Kalenjin community. So I'm asking, is that public knowledge?
Okay, may I explain that first of all, we are under obligation to make sure that we do not disclose the names of the witnesses, and we take that obligation very seriously for the security of the witnesses themselves and their families. And so
but do you know what he said? Do we know? Do Kenyans know?
Yeah, I'm coming to that point. Ordinarily, the court, after hearing a witness and after applying its mind on the testimony of the witness, would redact material that is likely to identify the witness. So quite a bit of what I'm referring to, and probably what that politician was referring to, is in the public domain, including the ruling I'm referring to and some aspects of that testimony. I can't say I know for a fact what the politician was referring to, and I don't want to go that direction. But aspects of the testimonies of these witnesses are in the public domain, and so it is not beyond possibility that somebody can make out sense out of what is in the public domain in terms of what the witnesses just said.
So, Mr. President, do you think what is happening in this country might affect your case at the witnesses?
I'm not quite sure what you mean by what is happening in this country.
There are articles in newspapers.
Yes.
Like I saw an article in the newspaper saying how Bensouda and the head of the ICC that case were working together before, and how they changed what the standards when you were working in Arusha. I don't know whether those kind of things might affect your case.
I shouldn't think so. I mean, I myself have worked in Arusha. I went to Arusha in 2002. I was in the defense. Fatu Bensouda was in prosecution. Judge Osuji was also there. Judge Frema, who was also sitting in that case, was one of the three judges in the first case that I defended at the International Criminal Tribunal for Rwanda. And I don't think those are things that really come to play on a day-to-day basis. And I think my message really would be that it is important that the politicians focus more on the political process rather than, that they focus more on the legal process so far as the case is concerned, rather than trying to make some political capital out of the case itself. I am convinced that the more politicians talk about the ICC process, the more, in fact, this would be harming the case of the two defendants before the court. That's my own personal thinking.
Is that your thinking?
Which one?
That the more the politicians talk about this case, the more they discuss it in Kenya, the more they want to malign the ICC. In fact, they want Kenya to pull out of the Rome Statute, the more damaging it is to their clients.
Like I said, I will restrict myself to the legal process, one. Number two is I am not prepared to advise politicians on what to do. They know what they are supposed to do.
And suppose they ruin your case?
I don't think they will ruin my case, because the rules exist. They govern how the process is going, and I don't think necessarily that what they say will form part of the court process. I am of course alive to the fact that one of the judges in public fashion of the ruling has criticized the conduct of some comments by politicians, but I remain myself focused on the legal process.
Well, I don't know. Would you want to say something about that?
Well, I think I would want to agree. I think we are lawyers, and I think that is part of the reason why we are finding ourselves constrained. We don't want to get into an arena that is none of our business, really. Let the politicians do their politics. But as far as the case is concerned, I think it's important that it be said that this is a legal process, and it is the subject of participation by Kenya as a state party in terms of ratification of the Rome Statute. It's a product of Kenya having been either unwilling or unable to prosecute the cases in the aftermath of the post-election violence. And I think we have crossed the political bridge. Let's get onto the legal bridge.
Well, suppose Kenya pulls out of the suggestion, we pull out, and the two witnesses don't cooperate. Suppose we don't cooperate.
I don't think it's that easy. It's not just a question of I'm annoyed and therefore I walk out.
Yeah.
There is a whole process under the Rome Statute that has to be followed, and even when they pull out, there is still a period of 12 months that would have to elapse before that pulling out is final. But again, let's remember that even if Kenya were not a state party, that does not mean that Kenyans would not be subject to the ICC process. And just by way of illustration, the case of al-Bashir is the clearest about on that issue.
What would you say about that? If suppose your client decides, or your client say, we will not go back, would you advise, we won't go back? If we are called there, we will not go. Because that's what the politicians are suggesting.
Well, I think my client is well advised. He would like to go through the whole process. He maintains his innocence and would like to demonstrate his innocence. So I don't think he has the mind to take the advice of politicians as opposed to legal advice. I am very confident that he will be there up to the end, and let me just emphasize that he is not about to abdicate the process. May I also agree completely with Mr. Nderitu that the issue of pulling out of ICC and so on and so forth will really not take away the burden of this case. This is a case which has to go and run through its course, and whether or not there is any process to pull out of the ICC will really not take away the process. That's how the Rome Statute is structured, that an ongoing case has to come to an end. It doesn't matter that you've pulled out. And even when you've pulled out, you are not beyond the reach of the ICC. And like he said, Sudan is a case in point.
You said you are not going to advise politicians what to say.
Yes.
But what do you think about what they're saying now? As a lawyer, they're talking about your case.
Yes.
What do you think about what they're saying?
I really leave it to them. I think I'm very clear in my mind what we want to do. For instance, we have filed an appeal. The details of what we've said and argued in our appeal, I doubt very much if those politicians know. And so my focus will remain on the legal infrastructure, the legal provisions, the legal circumstances under which we are conducting our trial. I will shut my ears to what the politicians are doing. I do not think that what I say one way or the other will make any difference to what the politicians want to do. And I leave it to them to do what they think is best. I think they have so far respected also the legal process in the sense that they have not attempted, other than of course bordering on suggesting to my client that he shouldn't attend. I don't think they have endeavored to come too close to how we are conducting our trial, and I would like to keep it like that.
I don't know, Mr. Derito?
Yes.
What do you say about what you are hearing from politicians? Might it interfere with your...
I think the position of both Mr. Derito and myself is clear. You're asking us almost the fourth time that question.
Yeah. Okay, what about your appearing here in this TV station?
Yes.
And answering this question?
Yes.
And do you think that might compromise your appearance in the ICC?
Definitely not. I think there is... well, I'm clear in my mind it doesn't. And part of the ICC cause and concern would be that what they do is understood, and nothing that I've said is not in the public domain. Everything I've said is in the public domain, and there is nothing that compromises my situation.
Gentlemen, thank you very much.
Thank you too.
Almost right time. Let's go and listen to the band that is playing from the coast.